Hello, welcome to EPG Pathshala. I am your course teacher Maruk Aidenwala. The course Legal Literacy, Module 6. Topic Constitution. This is the last module which we will be dealing with regards to Constitution. Now we are going to look at a directive principle, Article 39A. This directive principle is titled Equal Justice and Free Legal Aid. This directive principle's focus is to ensure that every person has legal representation, whether he be an accused or whether it be a person who is filing the litigation. Now let us see what Article 39A states. It states that the state shall secure that the operation of the legal system promotes justice on a basis of equal opportunity and shall in particular provide free legal aid by suitable legislations or schemes or in any other way to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. This article is based on the fact that every person is entitled to attain justice. A person cannot be deprived of justice merely because he does not have the monetary capacity to engage the services of a lawyer. Hence, it is the state's responsibility to provide a litigant with a lawyer so that he is able to fight his cause. To effectuate Article 39A, the Government of India has enacted the Legal Services Authorities Act 1987. The objective of this act is to ensure that any person who wants to litigate is not deprived of this opportunity merely because he does not have the monetary means to engage the services of a lawyer. This is the objective or preamble of the Act. An Act to constitute legal services authorities to provide free and competent legal services to the weaker sections of society, to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. This is the aim and objective of the Act. How is a person able to obtain free legal services? For that purpose, the state has enacted Legal Services Authority at the national and at the state level, as also at the local level. There are also legal aid committees in different courts to provide a litigant with legal aid services. The importance is that it is not only free legal services that requires to be provided, it should also be competent legal service. Section 12 of the Legal Services Authority Act 1987 deals with who is it that should be provided with free legal aid. One is a member of scheduled caste or scheduled tribe. Two, victim of trafficking in human beings or beggary. C, woman or child. D, person with disability. E, victim of mass disaster, ethnic violence, caste atrocity, flood, drought, earthquake, or industrial disaster. F, industrial workman. G, person in custody. H, whose annual income is less than rupees 50,000. In event of matter in court other than Supreme Court, and annual income less than rupees 50,000 in event of matter in Supreme Court. So the ultimate essence of this law is to ensure that everybody is able to engage the services of a lawyer so that he is able to agitate his cause. A person should not be deprived of his legal right merely because he doesn't have the financial means to pay the fees of his lawyer. The state should ensure and create bodies of lawyers who will agitate and litigate on behalf of a litigant who is unable to pay his professional fees. Article 40, another directive principle, is titled Organization of Village Panchayats. The state shall take steps to organize village panchayats and endow them with such powers and authority as may be necessary to enable them to function as units of self-government. Article 40 reflects that there should be sharing of powers between the state government and the village panchayats. This is very important to ensure that the interests of the persons at the village levels are reflected in governance. To enforce this directive principle, every state government has enacted the respective Panchayat Acts. These acts lay down what the powers of the village panchayats are. In fact, there are schedules in the constitution which lay down the duties of village panchayats. Decentralization. One of the main objectives of Article 14 is decentralization. There should be a bottom-up approach to administration. The person at the central government level should know what the needs of a person in the village are. For that purpose, it is very important to know the views of the person at the village level. A person should be able to participate in governance. It also democratizes the control of distribution of resources at the local level. We all know that resources in India are very limited. How best should we utilize these resources should be a decision left at the village level. It is very important that state government should devolve some of their powers upon the panchayats, because the panchayats know what the people want and what is appropriate for development of that particular village. The Panchayati Raj system is also based on democratic value. Can I go back to the earlier slide? Only from where I ended. Okay. As we all know, India is a federal democracy. Our constitution talks about sharing of powers between central government and the state government. Article 40 is further decentralization, that is, further sharing of powers between the state government and the panchayats at the village level. Article 41, the right to work, to education and to public assistance in certain cases. The state shall, within the limits of economic capacity and development, make effective provision for securing the right to work, to education and to public assistance in cases of unemployment, old age, sickness and disablement, and in other cases of undeserved want. Let's break up this provision into different parts. This provision recognizes that the state's economic capacity must be such that it may not be able to incur the financial obligation to bring this directive principle into effect. It all depends on the economic strength of the state. But it is important to note that if the state is not able to take care of the needs of a person, it is important that he be able to secure the right to work so that he is able to take care of himself and his family. The right to work, if it is guaranteed, only then will a person be able to feed his family and take care of their other needs. The state has enacted the National Rural Employment Guarantee Act 2005 to bring into implementation the right to work in rural areas. a person in a village has the right for 100 days of work. The right to education. The right to education of a person between 6 to 14 years of age is guaranteed under Article 21A of the Constitution. But inclusion of education in Article 41 denotes that the state is also obligated to provide opportunities to education and work for those beyond 14 years of age. Hence, higher and secondary education is also a duty of the state. The right to public assistance, unfortunately, has not been implemented. Nothing much has been done by the Indian state regarding social security. So, in case of unemployment or old age, a person is dependent upon the other members of the family for their survival. Article 44, Uniform Civil Code for the Citizens. The state shall endeavour to secure for the citizens a uniform civil code throughout the territory of India. The Uniform Civil Code is currently a very topical issue. What Article 44 implies is that in India, family-related matters, that is marriage, divorce, maintenance, adoption, succession, depends upon the religion a person follows. There is no uniform law throughout the country. In Muhammad Ahmad Khan versus Shahbanu Begum's case, which is commonly called the Shahbanu Begum case, the Supreme Court was moved with regards to maintenance of a Muslim wife. In Salla Mudgal versus Union of India, the Supreme Court was moved with regards to a Hindu male converting to Islam, thereby depriving the first wife of her rights. In Lily Thomas versus Union of India, the Supreme Court has clarified that courts have issued directions with regards to Uniform Civil Code, but it is a mere expression of views on facts and circumstances of this case. In Shahbanu Begum's case, the husband was refusing to maintain his wife, whereas in Salla Mudgal's case, a husband converted to Islam to remarry. What the demand at this stage, it is important to note that many believe that the Uniform Civil Code should be implemented step by step. The first concentration on the government should be on creating gender-just laws. What do we mean by gender-just laws? Gender-just laws are those laws which treat the male and female within a particular religious community in the same manner. Hence, many believe that the focus of the Indian state should currently be on creating gender-just laws, because it is noticed that family laws which are currently in practice discriminate against women. Article 45 has been reworded by the 86th Constitutional Amendment. Article 45 as it stands today deals with provision for early childhood care and education to children below the age of 6 years. The state shall endeavour to provide early childhood care and education to all children until they complete the age of 6 years. It acknowledges that early childhood care and pre-primary education is imperative for healthy development of a child. Prior to the change which was brought about in Article 45 in the year 2002, the earlier Article 45 provided for compulsory education for all children between 6 to 14 years. With the inclusion of Article 21A of the Constitution now providing education to children between the age of 6 to 14 years is a fundamental right. Hence, Article 45 has been reworded to include children only up to the age of 14 years. Hence, now Article 45 has been worded to include children only up to the age of 6 years. Above 6 years, they are dealt with under Article 21A of the Constitution. Let us look at the journey of the right to education under the Constitution. Earlier, education was a directive principle under Article 45. All children up to the age of 14 years were covered under Article 45. But one will notice that the earlier Article 45, recognizing that education is extremely important for a development of a child, had stated that this directive principle should be implemented within 10 years of the Constitution coming into force. Sadly, the state did not bring Article 45 into force. Hence, the Supreme Court included right to education to fall under Article 21, which means right to life. The Supreme Court held that for a decent life, a person should attain some form of education. But now, in 2002, Article 21 has been inserted into the Constitution of 21A has been inserted as a fundamental right under the Constitution of India, but it merely talks about a child's fundamental right to education between the age of 6 to 14. Hence, for a child below 6 years of age, Article 45 was also reworded to as it currently stands by the 86th Amendment in 2002. Article 51A also has placed right to education as a fundamental duty. The parents of a child are obligated to provide a child with education. Right to education has also been placed under fundamental duties, that is Article 51A. That too was incorporated in the Constitution by the 86th Amendment. Now a parent or guardian of a child or ward has a fundamental duty to place his child in school. Article 46. Promotion of educational and economic interests of scheduled castes, scheduled tribes and other weaker sections. The state shall promote with special care the educational and economic interest of the weaker sections of the people, and in particular of the scheduled caste and the scheduled tribe, and shall protect them from social injustice and all forms of exploitation. To make economic social justice a reality, it is important for the state to put into practice Article 46. Article 46 goes much beyond Article 45 because Article 45 merely deals with the educational interest of those between 6 to 14 years. Hence, under Article 46, the state should also be concerned with primary education and secondary and university education, especially for those belonging to the weaker sections of society. Under Article 46, the state is also mandated to ensure people belonging to the weaker sections of society are able to attain social justice and free themselves from all forms of exploitation. Hence, Article 46 is extremely important to create an egalitarian society where everybody has an opportunity to education and to attain economic justice. Article 48. Protection and improvement of environment and safeguarding of forests and wildlife. The state shall endeavour to protect and improve the environment and to safeguard the forests and wildlife of the country. Pursuant to Article 48A, the central government has enacted several laws for the protection and promotion of environment. Protection of environment is a fundamental right under Article 21 of the Constitution, a directive principle under Article 48A of the Constitution, as also a fundamental duty under Article 51A of the Constitution. Our Constitution makers realize that environment plays an extremely important role in enabling a person to lead a healthy life. The Supreme Court has on several occasions identified that right to clean water, right to clean air are fundamental for the survival of a human being. There are several principles with regards to environment that the Supreme Court has voiced. Two of such principles are the precautionary principle and the polluter pays principle. The precautionary principle is based on the understanding that the state should take whatever steps possible to ensure that environment is not degraded. Preventing environmental degradation is a prime duty of the state. The polluter pays principle is based on the understanding that the party who damages the environment should pay and bear the financial cost to set right the damage caused. So in short, what we are saying, the polluter should pay for the damage that he has caused to the environment. Article 51 deals with promotion of international peace and security. Please read it carefully. Most important is Clause C. Foster respect for international law and treaty obligations in the dealings of organized people with one another. There are several United Nations human rights treaties. They cover different subjects. What Clause C does is it obligates the state to adhere to the principles laid down in these human rights documents. It is not acceptable. No, sorry. I can just 1 minute. Yeah? Double standards of the state are not acceptable. A state makes several promises on the international platform, but when it returns to the country, these promises are violated. Under Article 15, Clause C, a state must abide by the promises made on the international platform. If not, people can make use of Clause C of Article 51 to ensure that the state respects the promises it has made on the international platform. This judgment of the Supreme Court opines about the applicability of international law within the country. It clearly says that when within the country there is any legislation which conflicts with international law, such legislation will prevail. But if there is no legislation within the country dealing with a particular aspect of international law, then the provision of international law will apply. There is also another argument which states that when a country ratifies an international law, it should abide by its provisions within the country. Double standards cannot be allowed. Hence, social workers play an important role in ensuring that the government abides with the promises it has made on the international platform. We will not tolerate promises made on the international platform which are constantly violated within the country. There are several other directive principles, but we have concentrated on a few of them. The Government of India has enacted laws to bring many of these directive principles into practice. Important reading material is, in fact, for all the earlier 6 modules, is the Short Constitution of India by D.D. Basu. With regards to Article 39A, it would be very interesting to read Law, Poverty and Legal Aid, Access to Criminal Justice by S. Muralidharan. The judgments which I have relied on can be recovered through the Indian Qanun website.